and welcome to a new episode on Hyperbolic Orbits. And for the first time today, we are going to talk about a field of space that we generally do not hear much in tech circles. We are going to talk about space law, and to enlighten us on this topic, we have with us Dr. Upasana Dasgupta, who is an assistant professor at Jindal Global Law School, OP Jindal Global University, Sonipat in India. She teaches courses such as International Law of Outer Space, Public International Law, and Legal Research Methodology. She has also taught a course on domestic space laws across various countries at the Faculty of Law at McGill University in Montreal, Canada. Dr. Dasgupta holds B.A LLB honors from Dr. Manohar Lohiya National Law University in Lucknow. Dr. Dasgupta also holds a Doctor of Civil Law and a Master in Air and Space Law degree from the Institute of Air and Space Law at the Faculty of Law at McGill University. Her postdoctoral research at the Canada Research Chair in International Political Economy, Laval University, Quebec, explored the intersection of law and political science, focusing on diverse interpretations of the common benefit principle among space actors. She is vice chair and member, board of directors of ACES Worldwide, which is a non-profit organization promoting equitable space laws and policies, where she leads the Space and Sustainability Compact Agreement Initiative in South Asia. Dr. Dasgupta is also actively engaged with the International Astronautical Federation, IAF, Technical Committee on Space Traffic Management, the International Academy of Astronautics Committee on Space Debris, and the International Institute of Space Law that we know as IASL. Dr. Dasgupta, thank you so much for being here with us today.
Thank you, Shumana. Thank you so much for the invitation. And before I start, I just want to commend for this extraordinary initiative that you have on this. I had the pleasure of listening to some of those videos, watching some of those videos, and I think that what you are doing is something that is very much needed today. I just want to harp one thing, and this is something I have been talking recently, that we talk about space among space circles, but it's so important that we make it more accessible and to everybody, and so that everybody understands what space is, because it has benefit for everybody. So thank you for doing this.
That's really, really kind of you. Thank you so much. So let's begin with our standard first question. Tell us about what you studied and how has been your career journey so far.
So as you graciously mentioned about my journey, so what I did initially was, of course, I was doing space law degree, my 5-year law degree. And it was during that time that I had the opportunity to participate in a moot court competition called the Manfred Lachs Space Law Moot Court Competition. And I was in my 2nd year of law school, I think. So when I started, and there was no reason why I chose that moot except that it dealt with international law. That's all. I mean, that's all I knew. And people said that it is a prestigious moot. I think there was no really any reason except that people were doing it. And I think, and I do commend the fact that IASL, which organizes this, does this, because there are people like me who might have got hooked onto space law, even though they had no intention to at that point. So yes, 2008 or 9, I think that's around the time when I started reading space law books. I actually, the first space law book I read was by Francis Leal and Paul Larson. It's a book on general, space law, the treaties and general principles. And it's a very good book for a starter. And I think the more I read about it, I got hooked. Yes, and I think it's also true that I really think what I really like about it is that it is very creative. There's a lot of opportunity for creative engagement. Like you can think about a lot of things out of the box and how to implement it, or how to implement what it exists, or how to make it work, or even how to make the existing principles better, however you're working on. There's so much place for using your creativity. I think I absolutely loved about that. And then I did my master's at McGill, and then I initially for 2.5 years I worked in law firms in India, and then I went back to McGill where I did my PhD. Then I eventually did my postdoc also, where I talked about, as you said, the intersection between space law and international relations, and looking at some of the different divergent voices of Global South, particularly. And right now, as you mentioned, I'm working at Jindal Global Law School as an assistant professor.
That's so lovely to know. I was lucky to study engineering in the college. We also had a law school, and these moot courts were one fantastic event that for the students, they got so interested. But if I ask you really, what is space law? What would you say?
So, first thing I would say, space law is not about having a habitation in Mars. I just want to harp that, because I think a lot of questions that I do get is, have you ever been to space? And then what is the point of space law if you have never been to space? So I just want to say that, there are more mundane things that are actually governed by space law. For example, the satellites that we have are governed by space law. And by satellites, I mean, we know we are using the satellite, the GPS that we use on our phone. Of course, those are all satellites, right? Then, of course, there are so many telecommunication satellites, there are remote sensing satellites. There's so many satellites now that all of us use on a regular basis, and we don't even think about it. And those are all governed by space law. So yes, so that's one thing. So space, I for the benefit of the listeners, I just want to say that there are three kinds of space applications that we generally talk about. One is telecommunications, one is navigation, and the third is remote sensing, or which can also have reconnaissance, however you call it. So, and or the art observation. So these are the three kinds of satellites applications that are there, and those we use in regular life. And then, of course, there is the matter of going to space, human space exploration, going to even, the about 100 kilometers, which is kind of thought to be a suborbital tourism. So that, then of course, there is the matter of going to moon and Mars. So, but all of these, because whenever there's a human activity, it has to be governed some way. And so whenever we do anything, anywhere, it has to be governed. So space, I just want to harp on this. It is not a vacuum. There is law, and it has been there for a long time, some of the laws at least.
That's good to know. That's quite, I would say, it sounds of a hopeful future that we are venturing into the final frontier with governance. Now, talking about space law, we have to talk about the role of UN. So, could you please tell us what the role of UNOOSA and how they fit into the dialogue of space law?
So UNOOSA is basically the secretariat of the COPUOS. So COPUOS deals with peaceful use of outer space, and that is what its mandate has been. And right after Sputnik was launched, which is 1957, we have COPUOS being set up. So it has been for a long time that COPUOS has been set up. And UNOOSA, as I said, it works as a secretariat for COPUOS. The decision making is mostly at COPUOS, but UNOOSA does a lot of important work too. For example, I just want to uh, give an example that they have been doing great work on finding out the registration practices, and whether there is a double registration by mistake, or if there is no registration but they should have registered. They are actually have created a index basically, which is very helpful. They're also doing a lot of capacity building, so they are doing great work. Also, UNOOSA also works for the UN Spider, which basically works for the disaster management. So that is also something, because there are many space agencies which have come together, and space has proved very useful in disasters. So that is also something that UNOOSA is kind of taking care of. So it is doing a lot of things, but I think primarily what I want to talk about is their role as a secretariat of COPUOS, where COPUOS basically makes the space laws on peaceful use of outer space. And we have 5 space treaties that was made in between 1960s and 1970s. And after that, we do not have a space treaty per se. And by treaty, I mean it is binding treaty obligation. There have been other soft laws that have been floated. But there is also the Cape Town Convention on Space Assets, which was adopted. The text of it has been adopted, uh, but it has not yet come into force because not enough countries have signed it. So at the moment, when we talk about space treaties, we generally refer to these 5 treaties that UNOOSA and COPUOS basically have come up with. So the 5 treaties are the Outer Space Treaty, the Rescue and Return Convention, the Liability Convention, the Registration Convention, and the Moon Agreement. And I want to say there are 5 of these, even though there are many documents which refer to only 4. One of the reason is the 5th one, the Moon Agreement. It has only 17 countries which have ratified it, so it is not very popular. So that's why often countries which have not ratified it do not want to talk about it. But then UN-wise, there are 5 multilateral treaties. And so I also want to say that there is International Telecommunication Union, which deals with distribution of orbital slots and radio frequencies in outer space. So that is also something that governs space activities. So ITU has a constitution, convention, and radio regulations. Those are mainly the things that govern space activities. And other than that, there will be other laws. International law in general applies to outer space. And this is something that Outer Space Treaty also talks about. General international law applies in any case to space, and this has been recognized by states right from the beginning of space age. So, of course, there are these treaties, but then general international law otherwise, which is not there in the treaties, if applicable, would apply to outer space too. And I said if applicable because there might be some situation where we are talking of just territoriality. In that case, it may not be applicable to the outer space regime, which is governed by freedom of exploration and use for all. And also there is this concept of non-appropriation of outer space and exploration of space for common benefit of all. So there might be things which is very territorial in nature and that may not apply to outer space, but otherwise it does.
That is really, really great to know. And I will come to the part because ITU is a very important aspect of any space exploration activity, and we'll come to that. But before that, I want to ask you a question where you cannot be shy. I want to ask you, having been studying and working in this field for quite some time, what, according to you, are some of your achievements that make you happy being a part of this sector?
That's a difficult question, I think. But I think some of the things that I have done is recently, actually, I co-authored a paper with uh, with one of my colleagues at Jindal. It's on how states are bound, whether they are bound, they're obliged to notify if they know through their space objects, space assets, they get to know that there's a disaster happening somewhere, and that disaster can be a space disaster, which is too satellites colliding, or it can be a disaster on Earth. So the question is, if you know, are you legally obligated to inform whoever is going to get affected? And when we worked on this, there are a lot of questions here because many states do inform. We do know there is something called space situational awareness. US does a great work. There's also India, Russia, China, who probably have some of the SSA facilities, and they probably do inform others. But it's always taken as a voluntary thing done. So what we were working on, whether it is a matter of obligation, and I think it will become very important to assert that it is a matter of obligation, so that A, we do not have less disasters on Earth, B, we have less collisions on outer space. So that's one of the things. Then I have worked quite a bit on space and sustainability on Earth. So there is a project that I'm working with McGill University at the moment, which is on space and sustainability in South Asia. So I have been working on particularly on the general South Asian thing, and I've also worked on Bangladesh, Bangladesh as well as some countries such as Afghanistan, then Bhutan, Nepal, and the Maldives. So those are some of the things I have worked on. But that said, I think the general conclusion I have got out of it is that the situation in South Asia is different in the sense, even India, considering that it's doing such great things in space technology. Even there, I think there's a difference in the what is important, because of course in India we have always thought that space applications using space for development is important, but I think in throughout South Asia, there is a problem also of people, not other people, not the space people as we call sometimes, but not non-space people are probably not aware of what is happening. And unfortunately, that from my experience, that is true for India also. So a lot of it when our project is also about this, but also we try to talk about role of space law and space technology in sustainable development in South Asia, considering that 2030 we are supposed to achieve the SDG goals. So those are some of the things that I have worked on, and based on the same lines, I have also worked on the space and sustainability a compact agreement initiative, which I am working as a part of ISIS worldwide initiative, which also tries to bring space users and space providers together and put them in partnership and see if we can have more use of space technology. And finally, last but not least, I cannot not mention this because this was my thesis, and I'm working on this as a book at the moment with Brill. So this is on preventing collisions in outer space through through state responsibility. So that is what I work on, the how you have space sustainability and how it can be enforced by enforcing responsibility of the states. So that is what my thesis was, and I defended in 2022. I am revising it right now as a book. Hopefully that will be done soon, but that is also something I absolutely believe in, that it is through enforcing state responsibility that we can have better space sustainability. I think those are some of these.
Some of them. Now, the reason I asked you this is exactly, you pointed it out, that we need to talk about what professionals do in space, really. Now, fortunately, we see in general media, we see a lot of spotlight on space science. Now we are fortunate to see it on our new founders, young people building rockets. But isn't there something you're missing out that may have included an international travel for you this year where you spoke at a brilliant platform?
So this year I had the opportunity to uh, be in Vienna and attend the COPUOS plenary meeting, and it was a wonderful experience, of course. And this was my second time attending COPUOS, and probably the first time speaking. So I had the opportunity to present a statement specifically regarding the Space and Sustainability Compact Agreement initiative. So I talked about how the importance of partnerships and also importance of dialogue and between states, and how states and how I and all the organizations that I'm associated with together can help in that that endeavor of the states, where they are specifically the emerging space nations, where they are trying to get the most maximum benefit of space, but they may not be able to as much. So that's the whole idea.
Thanks so much for sharing this. It was not to make you uncomfortable, but more to share that there are so many professionals in space, in academia, in industry who are keeping the sector going ahead. So now, Dr. Dasgupta, you're also a professor, so you have to please teach us a topic that you think is very valuable and you would like to share with us.
Before that, I just want to also say that the book that you have written on space careers, where you talk about different careers in space, I think that is fascinating in the sense that generally when we talk about space or careers, when whatever you see is mostly about space science and technology. So I was so amazed to see that, and it's very heartening to see that all kinds of space laws, social sciences that deals with space, all those were included in that book. So congratulations on that. Before that,
Thank you. Thank you. Thank you. I really appreciate it. That's very kind. Yes. So what would Professor Dashgupta teach us today?
today I am going to talk about international responsibility for outer space activities. As I mentioned before, this is part of my doctoral research also. So the reason it's so important because international responsibility in outer space activities is quite different from what we how we understand international responsibility in international law generally. So something that governs is Article 6 of the Outer Space Treaty, 1967. It uses the words that state parties to the treaty shall bear international responsibility for national activities in outer space, including the moon and the other celestial bodies, whether such activities are carried on by governmental agencies or by non-governmental entities. So I'll stop here. But what it basically says is that the Outer Space Treaty, which has 117 state parties, it basically says that these state parties, they bear the international responsibility for their national space activities. And these national space activities can be the governmental ones as well as the private space activities, which basically means that for private space activities, the government is directly responsible, the state is directly responsible. So basically, if I carry out a space activity in India, being an Indian citizen, India would probably be responsible for my actions. This has a huge implication in international law, where basically, in general, the 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 thing is, if a state, which is a country, by state I mean country here, a state does something, then the state is held responsible for it. If a private party does something, then the state is only held responsible if it is not taking action in case of a breach of international obligation. So for example, the private actor does something which is a breach of an international obligation, and the state does not take any action, only in that case there can be question of state being responsible. But that's not the thing in space law. I would try to use this diagram where I'm trying to explain the two elements of state responsibility. So state responsibility usually in international law have two elements. The first is attribution, that is the act that happens, that you have to link that to the state. Now, generally, it says that if you are trying to say that, it is done by the states, and it has to say some link, right? It has to be done by the government actor, or government has, given that instructions to someone, or it is under the control of the government. At least, very least, even if it is, outside the scope of their authority, there has to be some link with the government, generally in international law. But that's not what we say in space law. In space law, it has been modified, as you can see. So this attribution element has been modified. So for all national space activities of a state, be it by the government or by its private actor, the state is directly internationally responsible, which means it is responsible to other countries internationally. And the second element of state responsibility is that there has to be breach of an international obligation, which basically means that you violate some international law, which is not modified by Article 6 of the Outer Space Treaty. So that is retained. Because in space law, we say that in general international law applies, unless, of course, it's a special circumstance. So, of course, the attribution is a special circumstance, is a special law which has changed that attribution element. But that doesn't mean that the breach of an international obligation element is changed. So, basically, if there is an action which is a breach of an international obligation and done by a private space actor, in that case, a state can be held responsible. Now, I just want to say these two elements that I got are written in the Articles on Responsibility of States for Internationally Wrongful Act. This is something that was adopted by the International Law Commission, and then it was adopted by the General Assembly, and which does not make it a treaty, but it is a General Assembly resolution. But the reason it's so important is because it's a reflection of what the customary international law is. And so if you look at Article 2, it provides the two elements I was talking about. So moving on, I also want to talk about the history of state responsibility for space activities. Why is it so different? One of the reasons is that Article 6, it provides that the states are responsible for all national space activities. The reason is this is a compromise that early on happened between US's position, which said we want our private actors to be allowed to carry out space activities, and USSR stance that only the state can participate. Now, this is at that time when US and USSR were the main very big players, superpowers at that point. So at that point, it was their stance, which is very important. But the compromise happened because there was a lot of discussions, and ultimately it happened. The reason it's also happened is because there is ideological differences between the two countries at that point, and this has been during the discussions reflected also. So, and as we see, the compromise is reflected in Article 6 of the Outer Space Treaty, which is based on Principle 5 of the Declaration of Legal Principles, governing the activities of the states in the exploration and use of outer space, which was adopted in 1963. No, so what we are going to look at is the negotiating history of 1963 declaration, which ultimately the language of it was kind of imported more or less without much change in the outer space treaty. So what happened is USSR in 1962, they came up with a draft which basically said states will be solely and exclusively carrying out space activities. And Of course, US has said that this is not what is acceptable to us. We are planning to license anyway to private agencies. Now, USSR said, but this can create problems. For example, what if the private entity becomes bankrupt? We know, and at that time, space was even more risky. Even now, it's risky. So we know it's risky. So what if the private entity becomes bankrupt? Then, and if this private entity had hit someone else's property, then some other country can never get any compensation because this private entity has become bankrupt. So these are some of the questions that was brought, and they said that we do know that private actors can be irresponsible. So that's why it was suggested that let's stick to states. That's what USSR said. But later, the compromise that was reached, and Canada, France played a very big role in having that. They basically said, okay, let's allow both the private actors and the state actors to carry out, but that also means that ultimately it will be the states which are responsible. So I just want to say that there are consequences of breach of state responsibility, which basically means if there is a breach of state responsibility, then you can be asked to pay compensation. You can be also asked to satisfaction, which is basically apology or non-repetition. There can also a question of restitution. Now, I also want to bring the difference between state responsibility and liability. State responsibility is basically when, for the actions of the state, the private entity or the state is responsible, and it is any actions. Whereas liability deals with the fact about if there is a damage to another space object or to an aircraft or on Earth to another country. So liability, one of the important thing that has to be proved is damage, whereas in state responsibility, it is more about the terms of the activity. I just want to say that in law, we often use responsibility and liability interchangeably, but in space law, it's a little different, and that is why there is some confusion. Article 6 talks about state responsibility. Article 7 of the Outer Space Treaty talks about liability, as well as we have the Liability Convention, which deals with liability. I also want to say that there's a term that is there, appropriate state, which is responsible for carrying out authorization and continuing supervision. That is also a line that is there in Article 6. Now, appropriate state means appropriate in any given situation, and this can be defined multiple ways. Specifically saying that there can be more than one appropriate state, it basically means the state which has the ability to take action. And this obligation on the appropriate state is basically that it shall authorize the space activities of the non-governmental actors, as well as it will continuously supervise such actions. So it's not just at the launch that that authorization takes place, but also continuing supervision. Also, there's obligation of creating national space laws that often people say flow from Article 6. So, of course, it's a recommended thing, but Article 6 does not mandate any state to have national space laws. I think that's more or less it. So, thank you so much.
That is so lovely, Upasana. It is interesting, of course, but it's also highly insightful. Like I said, we do not get to hear this part of space when we study more about the tech and business side. So I'm very, very thankful to you for this presentation.
Thank you so much. Thank you so much.
Now, one topic that a lot of young people are interested in is the new space economy. So how does a space lawyer fit in the new space ecosystem?
I think it's twofold. One is, of course, helping in understanding what the space law is. I just give an example where space law's understanding is very different from general international law. So a lot of people do know general international law and how what the concepts are, but because space law is a little niche, so a lot of people do not know. So if someone does not know this, for example, that a private whatever private activity you carry on, it can have consequences. That might be a problem. Another thing I want to bring up is the liability that I talked about. The liability is fixed on the state of launch, or or the launching state, which has defined as four countries, which is the state, the state from whose territory or facility the launch happens, or the state which launches or procures the launch, which basically means that if your territory or your facility was ever used for launch, then you are liable as a state to, if there is a damage, which basically means that if I am using my territory to launch commercially, and that satellite at some point 10 years later hits someone else's satellite, there might be a question under the liability convention and outer space treaty. So those are some of the things that, now the question is this fair? I would say not really, because the rule is once a launching state, always a launching state, and it has some issues. But the thing is, as long as we do not change the treaty, as long as the law doesn't change, it is the law. So we have to either work around it or change the law. So to be very fair, often it is worked around through contracts, but not always, maybe.
Very, very nice to know, because it seems like that there are things when you start a venture, especially new space, which is trying to disrupt the old ways of working in space. It seems like, well, I have an expertise, I'll bring on a team and they will help me, which of course has to be done. But I think understanding the fundamentals of space law is non-negotiable. So thank you so much for this. Now, beyond the new space, let's say beyond startups or even the private sector, I do want to ask you, let's say, give you three scenarios that are common across the sector. And this is a question that I've picked up along the years from students and professionals, is how do space lawyers participate in these discussions? The first scenario is, of course, your field, which is space sustainability. The second one I want to ask is, we're talking about migration to other planets. And the third one, a very sci-fi one, is asteroid mining. So what would you like to say to that?
I will start with asteroid mining because that is easiest to talk about right now, because COPUOS legal subcommittee, and I want to say legal subcommittee, is right now working. They have a working group on space resources, and they are working on that. And they're trying to have something that works for everybody, taking into account all the established principles of space law. So yes, that is the easiest one to answer, because at the moment they're working on this. I think with space traffic management, it gets a little more trickier. One of the reasons is some of the space traffic management or SSA or all of these, there's a lot of, I think there is more of a lot of technical, as in the technological knowledge is required. And as much as we would all like it, it's true that it's difficult for social scientists, lawyers to talk with technocrats, technologists, because there's a difference of way of viewing things. So, which is why space traffic management, SSA, and also space collisions in general, avoiding that, debris, space debris, all of these, this needs a lot of communication, which of course is important. So, for example, we have the IADC space debris mitigation guidelines now, and that's great. That's absolutely great, because on the basis of that, we have the copious space debris mitigation guidelines also. And but then the question is that even if the content, now I'm not going into the content of it and whether it's updated or not. I'm not going into that. But the thing is, only a lawyer understands what is the authority of the document. So, for example, a technocrat can come and say that the IDC guidelines require you to do this, and a legal professional might say yes, but it's a soft law, so why am I bound by it? So I think something that law always teaches you is what is the authority of the document apart from reading the document. So I think for the reading the document, of course, we need collaboration. But for the authority, I think it's important to involve lawyers. And I think in national law, there are many kinds of documents. So it's binding, partly binding, not binding. It's a very difficult question. So that I think is very important to have lawyers and teams.
Thank you. Thank you so much. And may I ask about going to Mars part, which I tried to frame it as migration to other planets, but everybody wants to know what happens when we go to Mars.
So we do know that there is a principle of non-appropriation of outer space, which basically says that outer space cannot be appropriated by sovereignty, occupation, or by any other means. Now, of course, when we are talking about space resource extraction, there is some property discussion all anyway happening. But I think there have been cases. For example, when US first landed in Moon, they planted a flag, but that they had a law which basically said we are planting the flag as a symbolic thing. We have no intention to appropriate this. And USSR also made similar statements. China, for example, there was a particular Chinese entity which was trying to sell lands in Moon, and China said, no, you cannot. And this has happened in many other countries, and they have all said, the countries, private entities have tried doing it, and countries have said, no, you can't. And now they have stopped doing it because it's of no effect, they think. And they sell things for, say, $20, you're buying land in Moon, kind of a thing, Moon, Mars, whatever. So I think those happen. But I think the general understanding is you cannot own any land in celestial bodies in outer space. But that said, I just want to say that Artemis Accords, if I may bring that, Artemis Accords is the accords that US floated, and I think it has now around 56 agencies or states which have signed it. It's not a treaty. It is a political commitment. It is not a treaty. Explicitly, it says that it is not to be registered under UN Charter, which basically means not a treaty. And it also says it's a political commitment. So, and Artemis Accords basically governs when we go to celestial bodies. And Artemis Accords has two of the things which is often contested. One is the the extraction of space resources, which of course we're talking about multilaterally at the moment. The second one is safety zones. Safety zones basically say that if I am carrying out something, then I can mark some area around which is as a safety zone. And there has been a lot of discussion about what it means and how much can you demarcate as a safety zone. Of course, it is said that this is something we are doing for non-interference so that no one interferes into others and we don't interfere. So that's the harmful interference, to stop that. So that's a whole idea about it. But I think that there's a question about this, and it's a gray area about whether this amounts to appropriation or not. I also want to say on this line that if we are setting up colonies, either by setting up mini space habitats like space station like in space, or we are setting up colonies in Moon and Mars, the question of whether we are appropriating outer space comes up. And also it brings up a question about whether we are replicating the colonialism that we have seen in the past, so in the terrestrial scenario. I'm working on that, so I had to bring that up.
I'm glad you did. When I was studying space many, now I can say many years ago, I'm not that old still. But a good question that a lot of people would bring up is, do we really need to say we are going to colonize Mars given the history of colonization on Earth? So I am really, really thankful to you that you explained this so beautifully. And now, for the next generation of Dr. Upasana Dasgupta, anybody, a student who wants to take up air and space law, what would be your advice to them?
I think the first is, if you have the opportunity, do participate in Manfred Lachs. I think it actually gives you an opportunity to self-learn. And I think when you learn something by yourself, your interest is sparked. That's one of the things. But also in general, I think there's more and more opportunities coming up for space lawyers. So I think if it interests you, all I would say, do not be deterred by the fact that that there are not as many endeavors working on this, because I think now there are quite a few for one to find some way to work in the sector. So, and space law is incredibly interesting. I cannot even speak more about this, because I feel the reason that get up every day and feel passionate about it is just because I find it so interesting. And the more I read on it, I find it more and more, interesting. There's so much nuances, there's so much to learn every day. And yet you can bring all your creative self. There's so many other disciplines that you can bring in. For example, right now, as I said, I'm working with political science or international relations more specifically, and historical perspective, because I'm looking at some of the historical documents of terrestrial colonialism at the moment. There's so much link. And also right now, we're also talking about earth space governance, in the sense of that it's all interconnected, which we didn't think earlier. This, whatever happens in space affects Earth and vice versa. So today, I think there's a lot of opportunity. And also, I think there's this particular statement that government have made, our government, Indian government made recently during the National Space Day, is that we really want you to, be interested in the space sector, and we will provide you all the support. So I think that is really encouraging.
Thank you. Thank you so much, Upasana. This has been one of the most interesting episodes, I can say. And I think this is going to be the 20th episode. And
Wonderful.
thank you. And to everyone watching, I want to say that please, please keep following this podcast, because there are so many multidisciplinary professionals in the space field, and all of them are required to work together in collaboration to make space exploration possible. So thank you so much, Upasana, for taking the time out and joining us and explaining your work so beautifully today.
Thank you so much. And I also want to say that follow it for Ms. Mukherjee's excellent, insights that she brings up, and how she plans it. And it's really true that it's very important that we understand space from a multidisciplinary, interdisciplinary, different disciplines come. And so that's what she is doing. So yes, thank you again for doing this.